I'm going to talk to you today about discipline and performance in the workplace. And the first thing I want us to have a look at is what is poor performance and misconduct. Well, poor performance is essentially where an employee isn't doing the job that they're paid to do, or they're not doing that job to the required standard. Misconduct, on the other hand, is where an employee has broken a rule that an employer has, or they've behaved in a way that's inappropriate. I mean, the reality is these two things are a potential headache for employers, and they can both constitute potentially fair reasons for dismissing an employee. Now, whether or not they do constitute a fair reason for dismissal in any given specific situation is a really big topic, and I'm not going to talk to you about that today because there isn't sufficient time. What I do want to talk to you about is the steps an employer should take prior to deciding to dismiss an employee for these reasons. Rather helpfully, there's an ACAS code of practice telling us exactly what employers need to do prior to dismissing for either of these two reasons. So I just want to have a look at what the code actually says. So the first thing an employer needs to do is investigate the issue, and this could be by conducting an investigatory meeting or conducting an evidence gathering exercise. Once that's been done, the employer should write to the employee to explain exactly what the issue is, and they should give them sufficient detail to allow the employee the opportunity to respond. Within that letter, they should inform the employee that a disciplinary meeting will be held and when that will take place. And the final thing they need to do is inform the employee that they're entitled to bring a companion along to the meeting. Now, in my line of work, I'm quite often asked whether or not I can go along and be that companion with employees at disciplinary meetings. And the answer is, there's no reason why I can't go, but at the same time, there's no reason why employers have to let me. But the thing to bear in mind is, at this point, it's quite possible that an employee may have already taken legal advice in relation to their rights. So the next thing to do is hold the disciplinary meeting. And the purpose of the meeting is for you to inform the employee of the allegations against them, and give the employee an opportunity to respond, ask any questions, present any evidence, essentially let them put their case forward. So following on from the meeting, you need to make a decision about how you're going to handle the matter and what will happen next, and this can be a variety of things. So for relatively minor misconduct and very less serious offences, you might consider that a verbal warning is necessary. If it's a more serious offence, a written warning might be appropriate, or in cases of very serious misconduct, or in situations where a previous warning has already been given, a final written warning might be appropriate. And then the final option available to you would be the dismissal. So once you've decided how you're going to handle the matter and informed the employee, you need to give them the opportunity to appeal against that decision. In order to appeal, the employee needs to put their appeal in writing to you, stating the grounds on which they're appealing. And any appeal hearing needs to be held without delay, and where possible, it should really be conducted by somebody who wasn't involved in the initial disciplinary proceedings. And again, the employee must be given the opportunity to bring a companion along to that meeting with them. So that's a whistle-stop tour essentially through the ACAS code. And what I want to do now is look at how the ACAS code actually works in practice in relation to some recent cases that have been in the Employment Tribunal. The first case I want to look at is the Baby P case. And I'm sure you're all familiar with the facts of this case. It was very sad. Baby Peter was a child who was on the Child Protection Register at Haringey Council. Baby Peter had a social worker who was assigned to ensure his welfare, and that social worker should have visited Baby Peter every 14 days. Unfortunately, Baby Peter passed away in April 2007 as a result of injuries caused by his mother and two other individuals. Following Baby Peter's death, it emerged that the social worker who was responsible for his welfare hadn't visited him with the frequency that she should have. So there was a gap between the 20th of June and the 10th of July in 2007 when nobody visited Baby Peter whatsoever. So following on from his death, both the social worker and her team supervisor went through Haringey Council's disciplinary proceedings, and the result was that they were both issued with written warnings as a result of misconduct. And as I'm sure you're all aware, there was significant political and media interest in this case. And in November 2008, the government commissioned an investigation into the care services provided at Haringey Council. And the result of that investigation was that it identified some serious issues within the council and the services they were providing. And a new director of children's services was appointed. That new director considered that the way the Baby P scandal had been handled internally was inadequate, and he commissioned a new review into the scandal. And that included revisiting the conduct of the employees in question, so Baby Peter's social worker and the team supervisor. And a second disciplinary procedure took place, which resulted in both individuals being dismissed on the grounds of gross misconduct. Both appealed, and both appeals were rejected. And each individual then brought a claim for unfair dismissal in the Employment Tribunal on the grounds of double jeopardy, because the second disciplinary hearing and procedure had dealt with the same issues as the first, and in addition that there'd been an unreasonable delay between the conduct and the actual dismissal. There was an 18-month gap. And what the Employment Tribunal did was they looked at the whole issue. So they considered the fact that there was an ongoing criminal trial here. The initial disciplinary proceedings were wholly inadequate. There was significant media and political interest in the case. There'd been an overhaul of the management within the council that was responsible for this, and they'd taken a different view about the seriousness. And the Employment Tribunal said, all those things considered, it's okay in this situation that a second disciplinary was held and that there was a significant delay. And the individuals again appealed to the Employment Appeal Tribunal, and the EAT said it's fine. What the Employment Tribunal said was correct. In these circumstances, having a second disciplinary and a delay is fine. And what I don't want you to take from this case is that it's okay to hold multiple disciplinary proceedings in relation to the same issue, and it's fine to have an 18-month gap between the conduct and the dismissal. The point to take from this is that the Employment Tribunal take a fact-sensitive and common-sense approach to the application of the ACAS code. The second case I want to talk to you about is West Lothian Council and Mr Aziz. And I do want to apologise to any trainee solicitors in the room at the moment, because this really is the stuff that trainees' nightmares are made of. Mr Aziz was a trainee solicitor at West Lothian Council, and it was considered that his performance was inadequate. And he was given an opportunity to improve, and he failed to do so, and as a result he was dismissed. In dismissing the employee, the council failed to follow a fair procedure. And so Mr Aziz brought a claim for unfair dismissal in the Employment Tribunal. And the employer at the Employment Tribunal said, okay, yeah, we got the procedure wrong, we didn't follow a fair procedure, but even if we had followed a fair procedure, we still would have dismissed this employee, because in their eyes he wasn't a fit and proper person to be a solicitor. And the Employment Tribunal very much took pity on the trainee solicitor, and they said that they were 90% certain that had he gone on to qualify and been given the opportunity to improve following a fair procedure, he would have qualified as a solicitor, and so he was awarded 90% of his compensation. In the Employment Tribunal, there's a rule that if you follow an unfair procedure and dismiss somebody, if you can show that had you followed a fair procedure, you would have come to the same decision and dismissed the employee, any compensation awarded can be reduced to reflect that fact. And that's what the employer said should happen here. But as I said, the Employment Tribunal took a very sympathetic view and only reduced the compensation by 12%. The council was not surprisingly unhappy with this, and they went to the Employment Appeal Tribunal. And the AAT took a very different view, and they said, yes, the tribunal here was overly sympathetic to this poor trainee solicitor. And they looked at the facts a bit more harshly, and they said that, and I'm sure you'll all be pleased to know this, it's actually fundamental to being a solicitor that you're a trustworthy and honest person. And Mr Aziz, by all accounts, really wasn't. For example, he said that he volunteered at a local women's aid organisation giving free voluntary legal advice. But what he actually meant by that was he gave ad hoc legal advice to his girlfriend from time to time, which is a bit different. In addition, his exam grades tended to vary from job application to job application, as did his dates of employment. So there was a lot to bring into question his character, and the Employment Appeal Tribunal, said that coupled with the fact that he couldn't actually do his job, was a big indication that this chap was never going to be a solicitor, and so they reduced his compensation by 100%. So the point to take from this case is that even if in some situations you don't follow the code exactly, if it's the case that a dismissal would have occurred anyway, the Employment Tribunal does have the power to reduce any compensation accordingly. What I wouldn't recommend is that you rely on that, and it's always sensible to use and follow a fair procedure in the first place to avoid the question ever needing to be asked. The final case I want to talk to you about is Simmons and the Milford Club. Mr. Simmons was a steward at a private social club, and one of his responsibilities was to do the banking for the club. And one day he got in the car with his wife, went off to the bank to do the banking, couldn't find a parking space, it's happened to us all, and he pulled up outside the bank and said to his wife, "Will you just run in and take the banking and I'll wait here," which is what she did. This then came to the club's attention, and they were up in arms and issued him with a final warning on the basis that their insurance policy didn't cover any money when it was in the possession of somebody who wasn't an employee of the club. The point is, Mr. Simmons didn't know this, nor was he ever told that he was the only person that should be in possession of the money. Nevertheless, the final warning was issued and it went on his record. And then subsequently, in January 2011, Mr. Simmons was told by the club to give each employee a bottle of wine to the value of £15 by way of a Christmas bonus. And for reasons known only to him, he decided to give them cash of £15 instead, hence my witty pun at the bottom there. And the employers viewed that as a breach of instruction, and they dismissed him. And the reason they were able to dismiss him was because it followed the ACAS code, because he'd had the final warning and the dismissal then followed. Mr. Simmons wasn't happy with this, and he made a claim for unfair dismissal in the tribunal on the grounds that the final warning never should have been given. And the Employment Tribunal said, no, there was a final warning, then there was a dismissal, the code's been followed, everything's okay. Mr. Simmons then appealed again to the EAT, and they took a different view. And they said because Mr. Simmons had never been told that he shouldn't have given the money to his wife to bank, and because there was no written procedure stating that that was the case, the EAT said there was a chance that this warning could potentially be manifestly inappropriate. And in that circumstance, the Employment Tribunal should have considered the validity of the warning given because it was integral to the decision to dismiss. So what the Appeal Tribunal said was, we're going to send it back to the tribunal and ask them to consider the validity of the warning. And at present, that case is in the tribunal now, we're waiting for the decision. The point to take from that is that it's really important to make sure that any warnings that you are given to employees are appropriate in all the circumstances, because if they're not, and a claim for unfair dismissal is brought, if it appears that that warning might be manifestly inappropriate or has been given in bad faith, the Employment Tribunal does now have the power to consider the validity of it within an unfair dismissal claim. So that's everything I want to say about the case law. Now I just want to have a look at what you as employers can do to make sure that you don't get caught out by failing to follow the ACAS code. And it's really 3 simple steps. The first is to have a set procedure in place that complies with the code. The second is to follow it. And the third is to keep written records of exactly how you followed the code. And hopefully, if you do all of those 3 things, this should help you to avoid wandering blindly into any unfair dismissal claim as a result of failing to follow the code.